Reforming Texas's bail practices has been an ongoing battle. Late last year, a federal judge signed off on a legal settlement that largely ends the use of cash bail in Harris County for low-level offenses. It all started when a group of indigent misdemeanor defendants sued the county for keeping them locked up because they couldn't afford bail. The case has attracted national attention and inspired similar lawsuits. Whole states like New York now has a law that eliminates cash bail for misdemeanors and most nonviolent felonies. But not everyone is thrilled with the changes taking place. One of them joins me now. Ken Good is an attorney on the board of the Professional Bondsmen of Texas. Thank you so much for being on the program.
Thank you for having me.
I think the idea here is, how is it fair for a poor person to be stuck in jail and not able to pay bond when somebody who has more means with a similar crime is getting to walk free until their trial date is set? Why are you against that, or what are the problems that you see here of not reforming this system?
Well, the problems that we have are, how do we process large numbers of people in our largest counties across the country out of jail, where we keep up with them, we keep track of them, and we have accountability. What we are seeing now, like in Harris County in New York, is that we're trying just release everybody, and that's increasing crime, and that's causing public safety issues. And so the problem is, we want to improve the system, but how do you improve it without making it worse? And so the reforms that we're talking about, that we're seeing in Harris County, New York, California, are actually making the system worse. So we're not about keeping poor people in jail. I mean, the bondsmen don't make money off people who stay in jail. We want to ensure that people who have a right to get out of jail get out of jail. The 11th Circuit has said if someone's poor, they have to have a hearing within 48 hours. They get an elevated status. So they're not being discriminated against, they're getting elevated.
Well, I think the argument could be made, or some people might question, kind of the what's in it for you, because bail bonds industry obviously against this, because some of those bonds that are being paid are funded through those fees, or the
Sure.
bonds industry funded through those fees. So kind of the what's in it for you pushback there. What's your response to that?
I would say that the statistics show that your family member, if they're out on a bond, has a 500% better chance of going to court if they're on a private surety bond than if they're on a PR bond. And if I have a family out on a bond, I want them to get their case resolved, and I want them to be on a private surety bond because I know that they're going to go to court a lot more often and a lot more quickly. If you're out on a PR bond and nobody's reminding you to go to court, you're a problem child is one of the reasons why you're into the system, and you don't go, and then you don't go again, and there's no accountability, which is what we're seeing in New York. Then it bleeds over into the whole system. Well, if I can get away with missing court, I can get away with committing another crime.
There have been proponents, the Chief Justice
Sure.
here has also been, a proponent of some of this bail reform, and he's argued that not only it's just being not just too poor to get out, but there could be, if they're locked up and then re-offend because of what they've experienced in jail, and plus it costs taxpayers money. So what kind of reforms, could be seen to help alleviate some of these problems that you might be on board with?
Well, I think the first thing we have to come up with is a system on how to keep track of who's in jail pre-conviction. So, for example, if bail is set and they are still in jail 72 hours later, they need to be re-magistrated before the court to find out why you're still in jail. We have an example from Bexar County where a woman was magistrated and then on a $300 bond, and months later she died in jail of natural causes, but she never got out. Current law would have required she to be released within 30 days on a PR bond. It's just nobody knew she was still there, or they weren't keeping track. And so first of all, we got to learn how to keep track of who's in jail, and we got to have accountability. We don't have a problem with certain people. Let's give them a PR bond. Where we're having problems and we're having public safety issues is when they get a PR bond, fail to appear, 2nd, 3rd, 4th, 5th, 6th, 7th in Harris County, PR bonds, and with no end in sight. That means if they don't show up for court, they get rescheduled, the case gets put on hold. But if the victim doesn't show up just one time, the case gets dismissed because the complaining witness didn't show up for court. That's not fair.
I think you're kind of speaking to this, but alternatives to money bail and kind of what lawmakers have been pushing in the past, are you in favor of that at all, in terms of just kind of letting a judge kind of make some of these decisions?
Well, current law allows the judges to make those
Sure.
decisions, and what we're having is, from our friends on the other side, is they don't want the judges to use that discretion. They want to take the discretion away from them and just impose a requirement that they give everybody either just a release or a PR bond. The problem we're having with increases in crime is because all accountability has been taken away. And what we don't want is that. I mean, you've got to find a way to process large numbers of people in Travis County, Harris County out of the jail, and you got to have accountability. Letting everybody go doesn't do it. Using a bail schedule probably does, but setting up a system where somebody can be magistrated within 48 hours of arrest, if they're claiming poverty, to say we want a reduction in the scheduled amount, complies with the statute, that's what the law requires. It's just that our friends on the other side are asking for a whole bunch more than that. And really what they're saying is, if they're poor, they shouldn't be prosecuted because they're poor. That goes to punishment, not to whether there's been a crime committed. And we don't deal with guilt or innocence. We deal just with getting them to court. That's what we've been doing for 200 years.
What about the conversations, I mean, between the two sides? And, you know, we haven't seen this push from lawmakers this last time around, but there will be another push. We didn't see it pass last time around. There will be another push. Where are you in that part of the conversation?
Well, we're actively engaged. We're always meeting with all the different stakeholders. We've done that in the last 2 legislative sessions. You know, you've got the governor's office wanting to make sure that we include background checks or criminal histories in any review and setting bail. You've got the others. You've got the Office of Court Administration wanting to use a risk assessment, even though as more and more research comes out, they're saying that they should not be used. And then you have our friends on the other side saying we should not hold anybody. They should just all have PR bonds. What's not being looked at is the numbers of people with felony charges that are just waiting trial. I think something that's not being addressed is whether we just need more courts, because there's a backlog of people just waiting to be tried, and that doesn't have anything to do with misdemeanors. And I think you've got a big gap. You've got the lieutenant governor who says he won't let anything with a risk assessment get through the Senate. And so there's a big disparity that has to be negotiated between the different camps. And we're happy to talk. We'll talk to anybody on these issues. We feel like we're the most knowledgeable on these. We've written a lot of the bills that have been enacted in this area. So we're happy to be a resource and help. We want to make the system better. We just don't want to make it worse.
Ken, good, an issue we'll continue to watch, and we'll get you back in. Thank you so much for being on the program.
Oh, thank you very much for having me.
Thank you.